Ryan Alford, who has a new book out. That's a very important book about the sort of history and depth of our constitutional rights. And he'll join us to speak about things that he's watching and perhaps a little bit about his book. And then we'll get to some of your questions and comments. And we will have you off. We will endeavor to have you off by 1 o'clock. So the first thing that I just want to say, so who we are, a national legal charity, and we protect and defend constitutional liberties, is that I am really heartened that so many of you are here, that so many of you have reached out to us, that so many of you are alert to what's been going on with freedom, because I've been reading some very disheartening numbers across the free world of just the overwhelming support for draconian measures, the overwhelming support for things like mandatory vaccinations, which we'll get into, which many of you are concerned about, not that it's happened yet. And in general, when states of emergency happen, people's minds turn away from liberty and they tend to sort of give short shrift to our constitutional tradition. So I'm really glad that we can come together and talk about these issues, even while we are ourselves and our communities fearful of public health outcomes. So our main function at the CCF is litigation. We do cases in chief, we do interventions, between 6 and 10 interventions per year at all the levels of court, but we also ourselves sponsor litigation. We do education, we have a law intern program, we had 4 interns from the University of Alberta this year, and we have a summer intern, Josh DeHaas, who's on the call, who's been doing a lot of important constitutional writing and research for us, as well as communications. Obviously speaking to the media, bringing up issues and keeping the impacts on liberties as they pertain to constitutional law in the national dialogue. So the 2 cases that I wanted to speak to you guys about. So the first is our case that was brought on behalf of Dr. Brian Day, who has run a private surgery clinic, the largest in Canada, for the last 25 years, for most of those years with no sort of legal impediments. Around the early 2000s, because of some circumstances, change in government, he came into a dispute with the BC government, and the BC government held the position that he could not legally continue to perform private surgeries for those who were unable to continue waiting on a waiting list. We know that hundreds of Canadians die because of delayed treatment every year. And so our case is really a very modest case. The case has nothing to do with affecting the public health system, the Medicare system, which we and indeed everybody who's involved in this litigation are great supporters of. The case is just that if a province or government doesn't provide timely access to treatment for all its residents, at the same time, it can't proactively prevent them from taking their health into their own hands, which many of them do. We know by going abroad, going to the United States, going further abroad for treatment, we know that people will make these decisions about their health. And Canada is the only country in the world, and that includes communist China, it includes Cuba, that proactively bans all forms of private insurance in healthcare. And in terms of the trial, it's been going on for about 7 years. It's finally wrapped up. And the evidence really has been, the more granular and you get into the evidence, the more it's clear that the government can't refute the evidence that people are suffering on wait lists and suffering permanent medical damage and unfortunately sometimes death, as was the case of one of our patient plaintiffs in the case. The government lawyers have had an interesting litigation strategy. They've engaged in many, many delays and sort of side motions, clearly in the hopes that we would run out of funds. And often in court, I had the opportunity to observe many of the court proceedings in Vancouver. It would be about 20 government lawyers and 2 of our private lawyers who luckily are extremely able and up to the task. But otherwise, their litigation strategy included bringing in foreign experts that would speculate about the possible effects on public Medicare of allowing this private release valve. In any event, we did have a positive judicial outcome in December 2017. We brought an injunction against the government enforcing the provisions of the BC Medicare Protection Act that would effectively prevent these private clinics from operating. And the judge in that motion found that the suffering and the serious psychological and physical harms to suffering patients justified a judicial injunction against the government enforcing those provisions until a final determination of the trial. So that was our first sort of signal that we potentially were in good shape, that the judge accepted our evidence and the same arguments that we were making in chief. So what does this have to do with the pandemic? Well, it should be obvious on its face, but you may or may not know that in Ontario alone, as part of the pandemic preparedness plan, more than 70,000 surgeries, including cancer surgeries, including cardiac surgeries, were canceled at the beginning of March to prepare for a coming run on our hospitals. Luckily, that surge didn't come. But we know by public health estimates that in the province where I live, Ontario alone, about 50 people have already died because of delayed or canceled surgeries. And in British Columbia, the government has estimated it will take up to 2 years to catch up on their delayed surgeries. But interestingly, the BC Health Minister, Adrian Dix, announced that they would start subcontracting to private clinics in order to handle the surge. And there's two things to note about this. First, it would seem to directly contradict the government's argument in our litigation that the reason for long wait lists and absence of available surgeons was because of just surgeon capacity. There weren't enough surgeons, when in fact our argument was that in fact we have the surgeons, we have the capacity, but because of government rationing of how many people will have their procedures reimbursed, that's the cause of the shortfall, effectively, because the government is monopolizing healthcare. So we suspect that the whole complexion of this matter will look different after the pandemic. We think that allowing a private release valve, a private surge option is good for the public healthcare system because obviously it will take some of the pressure off. It's good for patients, and it will put Canada back instead of the rest of the developed world. We know that our hospital capacity has been in steady decline, and in a latest study among 24 developed countries, we have ranked dead last in a number of available hospital beds. So happy to answer any questions about that. The next case I'd like to bring to your attention, oh sorry, just to wrap that up. So the trial wrapped up in February of this year, and we actually expect a decision sooner than originally anticipated because of the court closures. The judge, Justice John Steeves, is working on the decision full time, and we may have a decision in this summer. We do expect that there will be appeals. It will almost certainly go to the Supreme Court of Canada. We also have a related matter compelling the government to disclose its litigation costs, which naturally it has fought. And that will be appealed also this summer. So please watch this decision. We really think that this is one decision that will affect every Canadian. Okay, so the other case that we wanted to bring to your attention is our charter challenge against Section 91 of the Canada Elections Act, which is to do with government regulation of information and political speech. So this provision came in pretty recently, although without much fanfare, and we were quite shocked when we learned about it. It was brought sort of in the hum of the holiday season, December 2018. So the provisions in question apply to any communication made with the intent to impact an election. So it could be a post on social media, it could be a tweet, whatever, and with the intent to affect the election. So our position is if you make a political statement on social media during an election campaign, it almost certainly at some level the intent is to affect the election. And the rules actually criminalize with the penalty of hundreds of thousands of dollars of fines and up to actually prison time on the distribution of fake news. And what is fake news? It's not defined, and it ultimately empowers the government to be the arbiter of what is fake news and what's not. And it includes innocent misstatements. So if somebody innocently retweets an allegation about not just a political party leader, not just Justin Trudeau or Andrew Scheer, but any figure associated with a political party leader. So there's a lot of vagueness in the categories. Anything from their professional qualifications. So if the allegations about Andrew Scheer's insurance broker credentials turned out to be false, they would seem to be captured under this law, and a false misstatement about those qualifications would be caught and possibly liable to criminal sanctions. And again, truth is not a defense. So we were clearly shocked by this law when it came to our attention. We're in general and on principle opposed to the criminalization of speech. We think that more open debate, more critical thought, and just generally a more vibrant public sector is the appropriate response to any concerns about fake news or false statements, and not to empower a government agency with being the ultimate arbiter of truth. But also you have a constitutional right that is almost certainly engaged in these provisions. You have Section 2B, which is the right to free speech and free expression. And furthermore, just to emphasize, these laws directly target speech during an election campaign, which is the speech that we most want to protect. We most want to have a vibrant town hall open discussion about political party leaders, their positions, and even if these provisions were never enforced, which it's not clear that they would or would not be, it doesn't matter. There's a chilling effect. And so if you know that this law is out there and it's hanging over the specter of the whole public sector conversation, you're going to soft pedal your expression. So what's been going on with this and the pandemic? So as our law intern Josh DeHaas brought to my attention, there was a news conference in the beginning of April where the health minister, Patty Hadju, was asked a question by a journalist about a Bloomberg report that China had falsified some of its statistics around the actual number of deaths due to COVID-19. And her response was that the journalist should not bring up such obvious fake news. Which was quite surprising because, as some of you are aware, there's been a sort of steadily growing body of evidence that China did falsify some of its statistics to do with the amount of deaths due to COVID-19. In any event, there seems to be a conversation that is fully within the bounds of reasonable conversation to be had, but it gave a suggestion of the government's stance to do with the boundaries of acceptable conversation and what the government would deem fake news. And so indeed, the president of the Privy Council, Dominic LeBlanc, CBC reported recently, has stated that the government is considering a COVID misinformation or disinformation bill. The NDP has already stated that they would support it. And so not only has the government not seemed to be troubled so far by the concerns that we and other people have raised to do with heavy-handed criminalization of news and expression, they seem to be doubling down. And truth is not a defense in already existing Canadian hate speech laws. So even if a statement was found to be true, if it was found to promote hateful attitudes, it wouldn't be a defense and the criminalization would remain. So just to touch quickly on a few of the other areas that we are watching outside of our active litigation. So first, there have been several interprovincial border closures internal to our country. Newfoundland, New Brunswick, Quebec, Nunavut. We find these offensive and unconstitutional in at least two ways. The first is Section 6C of the Charter, which guarantees free movements of peoples within the country. But probably even more clearly, it is in excess of provincial jurisdiction. Regulation of interprovincial travel, pipelines, highways, that is a federal power. And I will say that I've gotten some very heartbreaking personal notes from Canadians who have not been able to travel to attend funerals, be with ailing family members. There seems to be very little proportion in how these laws are being imposed. One woman was told point blank by a New Brunswick border agent that funerals were excluded from compassionate grounds for entry. And so this is something that really has to stop. People are clearly willing to take necessary precautions and to quarantine themselves, and just a blanket border closure is almost certainly unconstitutional. Second is various attempts. One is currently being deployed in Alberta of cell phone data tracking. Currently, the Alberta app, which is not mandatory to download, but is suggested to download, seems to have some technical issues where if you have an iPhone, you have to have it actually open all the time. So I think the compliance levels have been low. But certainly if governments were to make this mandatory, there would be an issue of privacy rights. And it's also unclear whether there's a real evidentiary basis in these apps. It could be over-inclusive in the sense that if you pass by somebody, but you're separated by a wall, you would be notified that you'd come into contact with the case, whereas if you order pizza and the delivery person brings the pizza to your door and leaves the car and the phone, then you wouldn't be notified. So my personal view is that these cause much more mischief than they're worse. Free speech, as I mentioned just a moment ago, the government seems to be edging closer and closer to proposing a bill to criminalize COVID-related misinformation. And the fourth that I want to just touch on very briefly, because we haven't seen any government action around this yet, although the New Brunswick Premier Blaine Higgs did suggest that he was close to taking action, is mandatory vaccinations. And I brought up at the beginning of our call that public attitudes are dishearteningly against the notions of liberty. And we know from recent polling that 60% of Canadians support mandatory vaccinations. Would this be constitutional? We don't think so. Josh has a great small primer on this on our website at the CCF.ca, and you'll see COVID Watch. The first issue is Section 7, right against interference with bodily integrity, which is a very strong right. And then, of course, there are issues about religious objections and just freedom of conscience as separate from any specific religious belief. So we would be alarmed and disheartened if a government or the federal government proposed such a measure. We know that in New Brunswick, where last year, before pandemic, there was a proposal to make vaccinations for children attending public schools mandatory, and the Premier proposed to pass the law using the notwithstanding clause, i.e. to exempt himself from constitutional review. There was such a big public outcry that he backed down. I think it would be likely in this case, but again, with 60% in favor of mandatory vaccinations, we can't know. So I'll be happy to take any more questions about that after we hear from Professor Alford. Before we turn to him, I just want to remind everyone that we are a private organization. We receive no government funding. And so if our work is valuable to you, we encourage you to donate at the ccf.ca/donate. And I'm happy to speak to anybody about any of our cases or any of our proposed cases. So I have the great pleasure now of introducing Professor Ryan Alford. This is his book, which has just been released on May 21st, 7 Absolute Rights. It's a fantastic book. It's very important. Perhaps when you see the title, you automatically think of our charter rights, but in fact, it's quite the opposite. He goes into the rights that have been part of our common Canadian tradition for so much longer that the framers of the Constitution thought they were implicit. And it goes into the history from Magna Carta up through the Glorious Revolution of the roots of the rule of law in Canada. It's a really wonderful book. I can't recommend it highly enough. Dr. Alford is a professor at the Boer-Alaskan Faculty of Law in Thunder Bay. He has a doctorate in public, constitutional, and international law from the University of South Africa. And one line that I read last night from his book, which gave me chills, but makes his participation even more relevant, was he said, "Canada has yet to face a serious crisis of the type precipitated by a terrorist attack within our borders, yet it's not too late for jurists to prepare for the inevitable attack on the rule of law which will follow." So it seems to me that such an emergency is upon us, and the attacks on the rule of law have indeed followed. So I will end my screen share and spotlight Professor Alford.
Well, thank you very much, Joanna. And I hope that everyone listening to this call has a sense of how important it is, not only to understand constitutional rights, but to understand how particular attention to civil liberties and a repository of knowledge for that understanding is so important in a crisis like this. Because if you take a look at the work that the CCF is doing, you see that it goes far beyond people's understanding of the Canadian Constitution, and perhaps even beyond most experts' idea about the Canadian Constitution. So one feature you may have noticed during this crisis is that when academic experts are brought on to public affairs programs, they almost inevitably answer questions about constitutional rights in a very problematic way. So the question comes, well, can the government really do this? This seems quite intrusive. So 99% of the time, my colleagues in academia say, well, the question is whether or not the measure is necessary and proportional to this kind of crisis. And given the scale of this crisis, as we understand it, the answer is yes. So the answer is yes, it's constitutional. Or they'll say, well, I think a court would be reticent to find this to be unconstitutional, and then they give you that necessary and proportional kind of analysis. And what's remarkable is that analysis applies only to the Charter. And organizations like CCF have brought successful constitutional challenges and are bringing constitutional challenges which have a high likelihood of success based on older constitutional principles that are not subject to balancing. So when Joanna mentioned Section 91 and Section 92, that of course is the 1867 Act, or what we would have called previously the BNA Act, right? Which doesn't have that structure, which comes from Section 1 of the Charter. And the problem with the Charter and charter rights generally is that we never considered the possibility of this kind of crisis when we built in Section 1. So Section 1 provides for the limitation of rights. You have these rights, but they're limited, right, in this sort of a situation based on these considerations of necessity and proportionality. I won't walk you through the whole test. But the problem is, in this kind of crisis, we always have the argument, well, what is your life compared to a million lives? How do we perform a balancing test on that basis? How do we perform a balancing test when someone says, I would like to see my dying mother in the hospital before she dies? And the government says, yes, but this would create some sort of risk to the general population that you would be a link in the transmission of a virus to an immunocompromised person. How are courts supposed to perform this? Never mind the question of how they're supposed to perform that balancing in this kind of overheated environment. In the environment where you see in the United States someone going into a grocery store not wearing a mask, and they're essentially shouted down and expelled from the grocery store. And of course, as we know, there are people with diseases or conditions like asthma who are advised by their doctors not to wear masks, right, for their own health. And those people, some of them in fact, may have had COVID and recovered from COVID. Maybe that's why they have respiratory problems and they can't wear masks. But, you know, well, how do we balance these things? Well, that's the way it works. We'll consider necessity and proportionality. It's wholly inadequate in a situation like this. And the core of the problem, as I understand it, is that we only see history as moving in one direction. If you have a view of history which says that, well, there's the bad old days and we're moving towards the utopian future, we don't need to think about the kind of safeguards that were painstakingly constructed over centuries to constrain governmental power so that we can have a rule of law state. Well then, just give the government all the power. No need for parliament to sit, no need for any considerations like habeas corpus. And frankly, it's absolutely remarkable. I was on a podcast with the former Attorney General of Ontario, who's also the head of the Civil Liberties Organization. And we were discussing the Quarantine Act, and there was no discussion of habeas corpus, which is absolutely mind-blowing. I mean, this is an essential bedrock protection that existed in our Constitution prior to 1867. But again, the problem is, when we constructed the charter, very few people thought, well, what about the use of these sections, like Section 1 and Section 33, in manifestly draconian ways in a way that exemplified previous crises? The October crisis, the conscription crisis of World War II, the conscription crisis of the First World War. Very substantial. Well, those things could never happen again because now we're so much more enlightened. But we see, and I think that history provides us with a far more nuanced view of the human personality. We see that in these crises, well, people are perfectly willing to accept draconian use of state power as long as it's seen as for a good cause. And almost invariably is. It's people who are calling for this kind of use of draconian state power. So if we don't have any absolute rights in our Constitution, and we do, pursuant to federalism, as Joanna mentioned, but if we don't have any absolute rights, we really don't have any rights in a crisis at all. Because it will be so easy to justify based on this open-ended balancing of what could happen. I mean, famously, Dick Cheney talked about the 1% doctrine. If there's a 1% chance of something happening, we have to treat it as if it's a certainty, given the horrors that would ensue if we didn't, right? And that was used to justify all manner of constitutional infringements. We think, well, that couldn't happen here, this is Canada. Well, that exactly is what I was contemplating in that quote that Joanna mentioned from my book. There will inevitably be crises that test the rule of law. And the most important thing for us to understand in that crisis is that proportionate balancing does not protect rights adequately during a crisis. We need to have absolute rights. And unfortunately, if we have only federalism, if we only say, well, this is beyond the scope of provincial powers, the problem is, the argument is going to be made, well, that then entails the statement that the provinces don't have the power, the federal government does have the power, or vice versa. So what rights do we have that neither the provincial government nor the federal government can violate? And they come from 1867, and they come into the Constitution recognized in a case called Provincial Judges Reference by then Chief Justice Lemaire of the Supreme Court of Canada, where it says Canada is guaranteed a constitution similar in principle to that of the United Kingdom. Now, the United Kingdom has a constitution. It is referred to as an unwritten constitution, but it's referred to as an unwritten constitution because there is no one document which summarizes that constitution. But as Blackstone noted, as all of the key constitutional theorists of the United Kingdom noted, it is comprised of documents. Magna Carta is part of the unwritten constitution of the United Kingdom. The Petition of Right is part of the Constitution of the United Kingdom, as is the Habeas Corpus Act, crucially in this kind of a crisis, as are all of the guarantees of judicial independence, which are necessary for any kind of rule of law, as the Supreme Court noted in that case that I mentioned. But if we don't have any appreciation of that history, you can't make arguments mobilized on those rights. So as a constitutional historian, I'm not trying to be an antiquarian. I'm doing this with the CCF and the challenges that they have in a crisis like this squarely in mind. Because if people think about the metaphor of being 11th grade, and you say to the professor or the teacher, but when am I ever going to use this trigonometry? Smart math teachers always say, the funny thing about learning something is, if you never learn it, you can never use it. In fact, you don't even know that you could use it. So this constitutional history is vital for this kind of a situation, because there are rules that are so fundamental that they weren't mentioned. So another metaphor I use in the book is, it doesn't say in the rules of chess that when you're losing, you can't kick over the board and say it's a draw, right? It's implicit in the rules. People who created the rules of chess had that in mind. Likewise, and I document this quite extensively in the book, likewise, the Farmers' Confederation had that in mind. We know that because of the period that follows from responsible government in 1849 to 1867. But if we're not teaching that history, the Canadian law schools, as they are now, are contemplating not teaching federalism, not even teaching the 1867 Act in first-year constitutional law. well, it's almost inevitable that everyone will think that the only constitutional rights that they have come in the charter. And that is very good for a particular kind of person with a particular kind of view of governmental power, because charter rights are subject to limitation under Section 1 and derogation under Section 33. That represents a massive exponential increase in governmental power. So arm yourself with history is what I would argue if you want to understand how people in these civil liberties organizations can bring successful challenges. I would recommend that you brush up on the history, and I've tried to do so in a way which is accessible and perhaps occasionally even entertaining. But I do want you to know that I wrote that book squarely with the purpose in mind of helping people in this kind of crisis to assert that there are rights that cannot be infringed, no matter how compelling the governmental objective. Because again, remember, it's the last point that I'll make. We thought until quite recently that Section 7 rights were effectively absolute. So your right not to be killed without due process, your right to security of the person, your right to life is a Section 7 right under the Charter. And no one would have argued at the time the Charter was framed that you could be deprived of your life in a manner which is not consistent with the principles of fundamental justice. But that could nevertheless be justified as a reasonable limitation of your rights. But that is the argument post-Carter that's being made by a number of academics. It's been made in a number of incredibly problematic circumstances. So if you think that the Charter is an adequate guarantee of your rights, I suggest that, well, the first review of my book in the Lawyer's Daily said that my book was scarier than any Stephen King novel. Because if you have this sort of complacent view of how history is moving in one direction, we don't need to examine our constitutional history. We have no need for these rights that protected us for centuries. You might be unpleasantly surprised. So with that, I would just say I'm very happy that I have the opportunity to speak to people who understand the importance of these issues, and most importantly, with people like Joanna, whose work that I hold in the highest esteem. There's literally nothing more important being done now than the work to protect civil liberties. And I understand it requires a tremendous amount of energy and a tremendous amount of resources to stand up with 2 lawyers against 20. But I know the lawyers that the CCF has retained. I've seen them correct legal academics' understanding of the Charter, including yesterday on Twitter. And I know that they need the resources to do that. And I would encourage you to dig deep if you can to support that work, because the precedents are being set now. The goalposts are always being moved. Even if this crisis proves to be transitory, as it very well might, those are the precedents that are going to be used in the future. Because when we're talking about constitutional challenges now, government lawyers stand up and file FACTA to talk about how In re Gray, which is a case involving conscription during the First World War, and the chemicals reference, which involves the War Measures Act, Second World War, they mention those as key precedents for what they're doing in this crisis. So please understand that your liberties moving forward depend crucially on how well they're defended now by organizations like CCF. So I would encourage you to think about that if you prize your liberties as I do. And I thank you, Joanna, for giving me this opportunity to speak about my book. I really am quite pleased with it, and I hope that you would be too, if you get a chance to check it out. So once again, thank you.
Thank you. Does anybody have any questions for Professor Alford? I've got one. Is there one area of government action that you're particularly watching, or one area that particularly concerns you? In light of your general skepticism of government action. I also should remind everybody that Ryan was our litigant in our action against the Law Society of Upper Canada in their compelled speech policy, which has of course been repealed. But that should just give you a sense of the disposition and chutzpah of this gentleman. Oh, sorry, you're muted. Let me unmute you. Ask to unmute. There we go.
There we go. Sorry about that. Just while we're waiting for more questions, just the one that leaps to my mind right now is how we're going to challenge the complete absence of parliamentary oversight. What we found out today is that the New Democratic Party made a devil's bargain, where they said in exchange for the promise, the mere promise of 10 sick days for Canadians, they would allow a minority government to continue essentially governing by edict. And if it hadn't been, by the way, for Scott Reid, MP, that would have included the ability to tax and spend and tax, to impose entirely new tax measures as they saw fit for the indefinite future, for the entire summer. Surely there is some sort of principle of responsible government that prevents Parliament from abdicating its responsibility so. Because remember, governments are responsible to Parliament. It's not vice versa. They're supposed to be continuously representative to Parliament. That's how the sovereignty of Parliament is maintained. That's how democracy works in Canada. So how can we challenge something so fundamental? For instance, John MacDonald never would have contemplated the idea that Parliament would just say, oh, well, we're not going to hold the governments responsible anymore as they tax and spend as they see fit with no oversight. Yeah, no, because we're worried about a virus, right? So how do we challenge this? It's going to require some very apt understanding of history to get at those constitutional issues. But it's very difficult just because we're seeing governments go further than they ever have before. We've never seen a government effectively say, we're going to rule without Parliament, and Parliament just say, yes, please do that to protect us from what we see as this crisis. Please remove all effective oversight.
Thank you. Does anybody have any questions? You can unmute yourself, or you can drop your question in the chat if you need me to unmute you.
Can I ask a question?
Sure.
So the numbers of this particular so-called pandemic are similar to the flu pandemic of 57, 58. And no one ever even considered any of these the crazy things we're doing now. What's happened between 1957 and now?
That's a good question.
Yeah, let me respond to that. So one point that I made in a lawsuit that I'm doing involving parliamentary privilege, I mentioned that Parliament sat and in fact debated in camera D-Day before D-Day. And the same is true for Spanish flu, the same is true for polio, the flu epidemics of 1957 and 1968. And now we seem to have this notion predicated on the charter, I would argue, that what the government can do is based solely on limitations of necessity and proportionality. Because there are no longer any governing principles. And essentially it shifts the discussion to one of policy. What is the best possible response? What should we do? Whereas I think that in the past, they would have said, where is the power to do what we would like to do here? What does it emanate from? Because with Section 1, particularly the way that the government uses Section 1, the discussion is always, well, can we justify what we want to do post hoc, rather than what is the source of our power to do this? And even when formally we didn't have entrenched rights prior to 1982, we still would have said, well, what is the precedent for the government to do this? So we've had a radical shift in the way that we think about governmental power. And I would argue that it shifted from a traditional understanding of Parliament, from governments, et cetera, to a far more open-ended, almost utopian view of what government can and should do. And unfortunately, it was also accompanied by a view of the Constitution, which shifts from a restraint on governmental power to effectively enabling governmental power via Section 1 and Section 33. And that's certainly the way that most law professors speak about the Charter. And I think that in part is part of that sea change.
Is a follow-up. Oh, this is from Steve Larson. Oh, and this is right in your wheelhouse, Ryan. At what point do you envision emergency powers will end? Is there anything you imagine can be done to compel government to end this obvious power grab? Well, my first point is just, as I say, one of the real truly disconcerting facts of this whole ordeal has been that public opinion, not just in Canada, but across the free world, according to recent studies I've read, I assume out of fear or out of just lack of vigilance, have been overwhelmingly in favor, for the most part, in these restrictions on liberty. Now, that may start to shift as the evidence starts to shift and as, frankly, fatigue starts to wear out, but I would say anything you can imagine to be done to compel government to end the obvious power grabs, it's got to start with the people. But Ryan, I'm eager to hear your thoughts.
I hardly concur, and I would say take a look at what's going on in Hong Kong right now. And again, think about the constitutional dimension of that. People in Hong Kong are protesting that the government of China is altering their constitution, the basic law, by passing a national security law that writes powers for the central government into the Constitution of Hong Kong. That's why they're in the street in Hong Kong. They understand the importance of their liberties. So, I mean, I think we have to push back against this logic, right? There's a risk here, and we can mitigate this risk, so therefore there's no limit on governmental powers, right? So, I mean, if Stanford is correct, and the risk to people under 55 is equivalent to commuting to work, right, in this crisis. That's the equivalent level of comparative risk. Well, couldn't the government just say, well, no, people shouldn't be driving cars? Because if we limit people's ability to drive cars, we make them drive bicycles instead, there'll be fewer fatalities. Think about the logic of this. And that, to me, highlights the need for absolute rights. And I would say the absolute right we need to focus on is the right to constitutional governance. So Boral Askin spoke about this in Thorson when he outlined public interest standing, a case I cited when I talked about parliamentary privilege. At what point do the Canadian people have a right to parliamentary sittings? When Parliament decides effectively just to delegate all the powers of Parliament to the cabinet and indeed to individual ministers, as the case in Alberta, at what point do we say that's not consistent with a constitution similar in principle to the United Kingdom, as they believed in 1867 when they framed the BNA Act? And that seems like an outlandish question, but surely there has to be a point in which governing by decree becomes unconstitutional. If not, why do we have a constitution at all? It exists at the pleasure, essentially, of Parliament. And the last question that I would say with respect to that is, Viktor Orban in Hungary was universally condemned for what he did with respect to his dissolution of the Parliament of Hungary. Look at every NGO, every civil rights organization. This is the death of the rule of law in Hungary. Please explain to me how what's going on in Canada is different. On any other level, it is not purely formal. And that's, I believe, what we have to say, and it has to be coming from the Canadian people. The Parliament must sit, and we must have the ability of our members of Parliament, whom we elected, to tell the government that this is no longer the way we want to live, given the level of risk that we are willing to tolerate as Canadians, whatever that happens to be.
Okay, I have a question that came to me privately, so I will not reveal the source of the questioner, but it's an interesting question. Hayek comments that liberty requires an atmosphere of freedom. If we had an atmosphere or tone in the public space that prized, very important distinction, if we had an atmosphere or tone in the public space that prized freedom and liberty, would the charter then work and protect us properly? Would you agree that part of the problem is the tone and atmosphere of the public sphere? Do we have a legal problem or a political problem? Very interesting.
That's a brilliant question. If we thought to ourselves, liberty is so important that infringements on it to be justified need to be demonstrably justifiable, things would look very different. Somebody in the comments mentioned the concept of reasonableness. Well, that's the problem. Reasonableness, as every lawyer is taught in the very first day of law school, is in the eye of the beholder. Oh, it's perfectly reasonable that someone be tortured, to prevent some sort of an atrocity. It's perfectly reasonable that someone be killed because they have 20 organs that could be used to save 20 lives. And by the way, if you study academic philosophy, you'll see numerous arguments that you would think to be outlandish, defended on the basis of a broad concept of what's reasonable. So yeah, I do think that to some degree, again, the way to think about this is that politics is downstream of culture. If we had a liberty-prizing culture, liberty-prizing political tone, rather than a far more reflexively deferential political culture, unfortunately. But I think that things can change. The reason why we've had a deferential political culture is because we've had a functional democracy where the rules operate to ensure good governance. As soon as the government throws out those rules based on principles like responsible government out the window completely, I think that people's willingness to do that may dissolve. And I think that we're seeing a major shift in Canada away from that kind of reflexive deference. That's why they need these fake news statutes. Because someone can say, hey, wait, didn't the World Health Organization say not to wear masks? Didn't they say it wasn't transmissible person to person in January? And now you're saying that it's fake news if it contradicts the World Health Organization, the World Health Organization when. So the mere fact that they're contemplating that kind of measure of information control, of speech control, shows that they're concerned about the end of that kind of reflexive deference, which is a very positive development. I guess that's the silver lining in what is a very dark cloud.
Yeah, I have just one follow-on comment that this is why one of our priorities is in education, because the atmosphere in which students learn about how to conceptualize their rights is so important. And that's why the Readymade Society, which is a national law school membership group that is a sister project of the CCF, is so dear to my heart, obviously given my history with it. But I truly think that the arguments, the pro-liberty arguments CCF makes, really won't get full purchase and expression until we can sort of shift the culture towards liberty. And education is probably the most important venue for that. And I'm sure Professor Alford, being in the trenches, would agree with that.
Let me just follow that very briefly. Besides my scholarly work, there's literally nothing I'm prouder of than being the faculty representative for the Readymade Society.
Ryan, will you just speak up a tiny bit? You're a little soft.
Oh, sorry, I think I might have overcorrected in
Yeah.
this direction.
Yeah.
So, because I hear there was some feedback. There's nothing I'm prouder of other than my scholarship than being the faculty rep for the Readymade Society. And the reason is this: the vast majority of law students are being told that the Constitution is a blueprint for achieving a utopian society, that the Charter is a means for governments to retroactively justify whatever they want to do to impose the kind of society that they prefer on everyone else whose views are retrograde. And that's just so acidic and so destructive of the kind of cultural liberty that we're trying to sustain based on open debate, based on open exchange of ideas. And I have to emphasize, what the Readymade Society does is completely unlike what anyone else is doing, and very much against the grain. They're the only people that sponsor any kind of substantive debate on controversial topics within any Canadian law faculty. And that's hardly an exaggeration. I think that's quite remarkable. So I think it behooves us also to thank people who've come up through Readymade and sustain its efforts, because that kind of culture within our legal profession can no longer be taken for granted.
I have a question.
Sure, go ahead.
Yeah, the role of the courts in some of this anti-freedom drift we seem to be experiencing. I noticed in this. I'm wondering if Ryan Alford has any comments on the practice of the Supreme Court of Canada, in particular, in referencing social trends in its reasoning and making decisions, rather than the law, rather than constitutional precedent, rather than our historic. The new social trends seem to be part of the reasoning. And so, does he have any comment on that?
I do, in fact. I saw that Professor Dwight Newman from the University of Saskatchewan was on this call. I remember his presentation, and the panel actually involved a number of other scholars associated with the Readymade Society at the conference 2 years ago on stare decisis, and how the Supreme Court has effectively said, well, and this is, of course, me bowdlerizing this jurisprudence. Well, that was Tuesday, and this is Thursday. Things have changed between Tuesday and Thursday, most notably in the reasoning of the plurality in Trinity Western, where Trinity Western came out one way with respect to the nursing school, and then quite differently with respect to its proposed law faculty on the basis of changes in society, right? And the way that religious freedom was to be balanced or not balanced very problematically against other rights or charter values, even more problematically. And there's been so much excellent discussion around the Readymade Society around that framework. But yes, with respect to having this living tree analysis of the Constitution, saying, well, what these rights mean is what we believe in society that they mean. It's always with this kind of particular view of what society thinks and what surely everyone must think now. Surely everyone must think X. Surely everyone must think Y. And that's how you get to situations where, in a crisis like this, we see no value whatsoever on people attending religious services. to the point where people who attend a religious service in their cars are being cited under emergency orders and they have to be sued. And the Premier of Ontario has to issue emergency guidance saying that no, something that on its face doesn't even violate the emergency guidelines shouldn't be criminalized just because we don't see any value to what people are doing. And what we need to do to fight back against this, in my opinion, is to say, well, tell me what rights you think are not evolving, what rights are fixed, and how do you believe that I have rights as opposed to the protections of benevolent government in the absence of these fixed conceptions of rights. And that leads also to a number of really interesting questions about constitutional interpretation raised by Leonid Sirota and Ben Oliphant, among others, about how we need to have a view of constitutional interpretation contrary to Living Tree, or an exclusive focus on Living Tree that includes some sort of appreciation of the historical context and the fixed meaning of the enactment.
Isn't there a secondary issue here about when the courts are using social trends, they're actually interpreting and applying social trends, they're usurping the role of Parliament?
I think that's absolutely true. I mean, you have to ask yourself whether or not you want a philosopher king, philosopher queen, Rosalia Bella et al. Kind of making decisions rather than Parliament. And what's remarkable is we've always thought about the judiciary as having a really important role to play because they're the least dangerous branch. That's a really important book in constitutional interpretation. Probably the most important book in constitutional interpretation to come out of the United States. Alexander Bickle's The Least Dangerous Branch. I mean, if all they do is constrain to the interpretation of law, then we can trust them with this power. But when they see their role as essentially refashioning social norms, that's even greater than Parliament's role. So they become something like a super parliament. So in addition to just usurping parliamentary power to write legislation, they do things that Parliament couldn't do under the constitutional limitations of legislating as they exist with respect to the absolute rights of Edgar Gale, for instance.
Thank you.
Thank you. So we have just two more comments that I'd like to address. The first from Karen, how can misinformation be true? Well, the point is that when you make the government the ultimate arbiter of what's true and what's false, you don't allow the sort of marketplace of ideas and the general progression of science to sort that out. So people who thought the earth was not flat would have been called fake news purveyors once upon a time. So misinformation can turn out to be true as we learn more. And certainly we've seen in this pandemic that the truth has been a moving target. Second question that we'll just briefly touch on, because unfortunately I don't have a very uplifting answer from Jim. I'm not looking for you to endorse a candidate, but can you give any indication which conservative leadership candidate would give Canada the best chance of sorting out constitutional issues? So I don't throw my hat in for anybody right now, but I will say that I thought the greatest act of political heroism this year in Canada was Scott Reed's insistence on Parliament continuing to serve its function and speaking out against the obvious power grab attempt, I guess at the 11th hour, attempted to be inserted by the Liberals. I believe this was in early April when they were proposing fiscal relief for the pandemic, but they also slid in a provision that would insulate them for review for about 2 years. And Scott Reed insisted on driving to Ottawa and sitting, as he is empowered in his role as a member of Parliament to do. So that's the type of spirit that we would like to see more of. I don't know, Ryan, if you have any comments on that.
Yeah, just with respect to fake news, I would say, who gets to decide? Why do we think the government is going to be a fair arbiter when it comes to this? So when it comes to a government, a minority government, which is prolonging its minority indefinitely by not holding parliamentary sessions, why would we think that they are so virtuous that they would say, oh, crisis is over, pandemic actually was far less severe than we predicted that it would be, time to get back to Parliament? Why would you think that they would not be self-interested? You know, I mean, just the fundamental principle for conservatives, power corrupts, absolute power corrupts absolutely. And that's the statement that's held up over time. Just with respect to candidates too, and boy, do I ever endorse what Joanna said about Scott Reed, who did this against considerable odium. Look at what was said about what he did. Look at what's being said right now, people who want to have regular parliamentary sessions. I would say that we have to put the question to the candidates, right? To every candidate in every leadership election, every party. What rights do Canadians have that at bottom cannot be violated, despite the fact that you think it might be necessary to do so? And I really think that the way people answer that question is quite indicative. Because again, if you're looking for people who have that authoritarian impulse, they'll just say, well, if I think it's right to do, there shouldn't be any limitations. My word is law, as it is with respect to individual Alberta ministers right now. And if you have somebody who has a thoughtful response and says, well, surely there must be some, there's a tradition which says that our power is limited fundamentally, government should be limited. That's what I would encourage all of you to ask of every candidate at every opportunity.
Okay, our time is up. It's been wonderful, and it's so wonderful to see you all and engage with you all. We'll almost certainly do another one of these later in the summer, probably in about a month. Yes, we will record this session and make it available. We'll also transcribe it because I know there were some issues at some point with sounds. And we'll make all of the content available for you. If you have more questions for me or for Professor Alford, you can contact me and I will make sure the message gets to him. Please visit the ccf.ca to see more about our cases and how to donate, and please buy Ryan's book, 7 Absolute Rights. Thanks so much, everyone, and stay well. Bye-bye.